Okay. So, um, there's a lot going on in immigration today, and we thought that citizenship process has had some changes, some announcements that we've received from the administration. So we believe this is a good time for those of you who are considering to apply for citizenship to understand the current requirements and how you can prepare to apply, as well as some other information about how certain people do obtain citizenship by other means besides naturalization. So, um, okay, but before I go on, I do like to let everyone know on the call that the information that we're providing in this presentation is educational in nature. It's general in nature. It should not be specifically applied to your situation without getting further advice or information from an immigration attorney who can tailor the information to your circumstances. But this is a good way for you to at least get a basic education about citizenship and then go from there to determine in your specific situation what your next steps will be. So today's agenda, we're going to cover 3 areas of citizenship, U.S. citizenship. We're going to talk about the roadmap to citizenship, how you apply for citizenship through the naturalization process, which is the formal term for that process for someone who is not a U.S. citizen, but would like to become a U.S. citizen. Then we'll also briefly talk about derivative and acquired citizenship, where certain people, depending on the circumstances of their circumstances, can already have citizenship or obtain citizenship without actually having to go through the naturalization process. And then we'll also talk about denaturalization. There has been more talk than ever about denaturalization, particularly under the current Trump administration, or even the previous Trump administration. There was a lot of discussion about denaturalizing people who had gone through the naturalization process, but for certain reasons, the government feels they should no longer be citizens. So we'll talk briefly about that and what that is as well. And then, of course, we'll have opportunity for you to ask questions. So as I mentioned earlier, when we started, please feel free to start as we go along, input your questions into the chat feature, and we will certainly circle back to them to answer them.
నేను
If
మర్చిపోయా.
you could mute yourself as well during the presentation.
రికార్డింగ్ కూడా ఉంటుందిలే.
So I
ఉంటది
appreciate
ఉంటది.
it. Sorry, I hear someone speaking. If you could please mute yourself. I'm not sure how to do it on my end. So if you could do that for me, that'd be great. So anyway, we're going to start out, as I mentioned, talking about the roadmap to citizenship. So to understand what are the requirements to become a citizen. So what is how are you eligible to become a naturalized citizen? What is the process for it? How do you prepare for, or what should you prepare for as far as the interview and testing is concerned? And then also briefly about your rights and responsibilities as a U.S. citizen. So let's go right in. So basically, to become a citizen, there are certain essential criteria. These are the very basics. There may be others as well, depending on circumstances. But in general, when you're looking to become a naturalized citizen, you want to be sure that you meet these certain criteria. So number one, of course, you have to be 18 years of age or older to apply to become a naturalized citizen. So children, or those under age 18 are not qualified to apply through this process. However, they may actually obtain citizenship at a younger age, depending on their parents' circumstances. And we'll talk about that later. Then we also have the requirement that you must be an LPR, which is lawful permanent resident. So you must have a green card. Lawful permanent resident is someone who has what's typically known as the green card. Either in most cases, you have to have that green card or have received that green card for and have held it for 5 years. Or if you are married to a U.S. citizen for at least 3 years at the time that you if you're married to a U.S. citizen, either when you got the green card, you were married to the U.S. citizen, then you would be eligible for within 3 years. However, let's say if you did get your green card maybe through employment, you got married to a citizen, and then you were married to that citizen for 3 years, then you might actually not have to wait the 5 years. You're actually now looking at 4 years since you received the green card that you're eligible. So the point is that if you're married to a citizen, you look at the 3-year timeline to see how long, to be sure that you've been married to a U.S. citizen for 3 years and you've been living in marital union. The other requirements are generally for everyone as well. Physical presence requirements, so which we'll talk about, and conditional residence requirements. Really important, good moral character. So we'll really talk more in detail about that because there has been some new information or directives by the USCIS regarding what they would consider good moral character. So we'll talk more in depth about that. And of course, speak, read, and write English as well. So, and then your knowledge of U.S. history and civics, which is government testing, that is also still required, has always been required there, but there are a few changes for those who are thinking about applying. And then, of course, you must be willing to take the oath of allegiance, which is the very last step of the green card, of the citizenship process. So let's talk about mainly continuous the residence requirements. So there's two parts to the residence requirement for naturalized citizenship. So what that means is that as a permanent resident, once you become a permanent resident, the clock starts to tick towards citizenship, and your residence now matters. And what do we mean by residence? So to become a U.S. citizen, you have to demonstrate continuous residence. That means that you're living in the United States as a green card holder, as a permanent resident for at least 5 years, or as I mentioned, 3 years if you're married to a U.S. citizen for that 3-year period. So you look at the timing of that really depends upon what your specific circumstances are. But during that either 5-year or 3-year period, you must make or be sure that your primary home is in the U.S. Certainly you can travel. Nothing says you cannot travel outside the U.S., but we have to be mindful how long you remain outside of the U.S. In order to comply with this requirement for citizenship as well. So we often hear about people often ask us about the 6-month rule, like if we stay out of the country for 6 months, do we lose the right for citizenship? And it doesn't necessarily happen, but isn't automatic that would happen. But if you, during your 5-year or 3-year period of permanent residence, if you take a trip that's more than 6 months outside the U.S., then there will be a question, or there will be considered that you have broken your continuous residence requirement. Now, that does not mean that you are disqualified for citizenship. However, if you have stayed out of the country for that time period of 6 months or more, then you will be asked to prove at the time you apply for citizenship or naturalization to prove that you still maintain the United States as your home. So you need to show things like you had property here, you had bank accounts here, you had a good reason to be outside the U.S. for that 6-month period or so. So there's a lot more that you have to do if you have broken that continuous residence. Also, there is another timeline to consider, that if you are out of the country for 1 year or more, then you have definitely broken that continuous residence. And what does that mean? That means that you have now pushed back your ability to apply for citizenship. So whereas you might have had only 5 years from the time you received your green card, but then you left the U.S. And was gone for a year during that 5-year period. When you return, you now have to wait another 4 years and 6 months before you apply for citizenship. So being out of the country for 1 year or more definitely breaks your continuous residence and almost makes you start all over again in terms of having enough time as a permanent resident in order to apply. So be very mindful of your trips outside the U.S. during your qualifying period, which is either 5 years or 3 years. And so you want to make sure you're keeping track of your trips, monitor your tickets, or make sure your tickets are that you track. Well, I say tickets, but basically your entry and exit from the U.S. and entry back into the U.S. You want to keep track of that, because that will be required on your citizenship application for you to give the timelines when you were actually outside of the U.S. And they'll also want to have your passport copies as well, to show any entry and exit stamps when you have traveled. So if your passport is expiring, make sure you at least keep a copy of that, even if you renewed your passport. So whenever we are applying for citizenship, we always ask for all passports that you've used in the qualifying period, that 5 years or 3 years, make sure that you have all of those passports, even if they have expired. The government will want to look at those to ensure that they have not that you have not traveled for more than or you've not broken that continuous residence. So in addition to the continuous residence, we also have what's called the physical presence requirement. So with physical presence, you are required to show that during that qualifying period, again, I keep saying it, but it's 5 years or 3 years, depending on your circumstances, you have been in the United States physically present, in the United States for that time, for one half of that time period. So if you're qualifying based on 5 years when you apply for citizenship, 5-year qualifying period, then you have to have 30 months physically in the US cumulatively. So again, any trips that you take outside of the US will be deducted from the usual 60 months. So if you're outside the United States for half the time over the past 5 years, you could still qualify, but you want to make sure that you can prove that you have actually been in the United States for that 30 months or so. And then also, if you're qualifying based on marriage to a citizen and a 3-year period, then you want to show you have one half of the 3 years that you've qualified for. So you want to make sure there's no single absence, as I mentioned before, of 1 year or more. As again, that breaks your physical presence, it breaks your continuous residence, and you have to start all over again. And also it can be an issue for your green card itself, to maintain your green card if you're staying out extended periods without prior permission. Now, even if you do get prior permission, for example, you get what's called a re-entry permit that basically says you still maintain your permanent residence, but you're going to be outside of the country for a year or more. That still does not change the required, that still does not allow you to consider that time outside the United States towards your citizenship. So if you are outside the United States for 1 year or more, even with permission to do so, it will break your physical presence and continuous residence, and you will be, or at least your continuous residence, and you will have to start over again in most cases. But as I mentioned in the previous slide, if you are outside the country for more than 6 months at a time, but less than a year, it does break your continuous residence, but it does not mean you cannot apply, but you will have to prove that you did not abandon your permanent residence in the United States. You did not abandon your home in the United States. Another requirement as far as residence is concerned when you're applying for citizenship is that you must be living in the USCIS service district at least 3 months before you file the application. So basically right now, for example, I am in Dallas area. And so we have the Dallas district office that covers the North Texas area. If I move to San Antonio, which is covered by the San Antonio district and other towns, covered by that district, then I cannot apply, even though I may be fully qualified otherwise, I cannot apply until I've lived in the San Antonio district for at least 3 months. So if you have plans for moving and you're close to applying for citizenship, you want to consider that as well in terms of when you can apply, or whether you should apply before you move and kind of at least get into the process. Because if you do apply before you move and you're in the proper district when you apply, even if you move, your application can still process. You just have to notify the government that you're going of your address change, and then they'll usually move your case over to the other appropriate district. But that will not invalidate your application in doing so. Okay, so now let's talk about good moral character. As I mentioned earlier, that is one of the most important, all of them are important, but this is one of the ones that is most critical in terms of approval of your application. So good moral character basically means that you have to prove that you've had good moral character for the same period as your physical presence requirement. So again, we're talking 5 years. So when you apply, if you apply today, the government is going to look back 5 years and look at what your character was during that past 5 years, or 3 years if you're married to a citizen. And there are certain acts or things that if you've done certain things or created certain issues, you may be denied citizenship. So we have, those are what's called bars. They're bars for you, bars against you actually receiving citizenship. So there's 2 types of bars to to good moral character and denial of a citizenship application. So one would be discretionary bars. So these are things that the government may still may find that these are issues that establish that you have not maintained good moral character. However, they can still, in their discretion, look at the whole picture and determine whether or not they're going to actually consider that to be an issue or approve your application. Then there are mandatory or required bars that basically the USCIS officers have no choice, that if you have those issues in your background, they cannot approve your application, even if they wanted to, right? So it's very important to understand the discretionary and required bars. I'm listing some of them here. These are examples. They are not exhaustive and not all they do not, this does not mean these are all the issues that they would look at. There could be others as well. But basically these are the required or mandatory bars where the government has no choice but to deny your application. So of course, conviction of murder, that would obviously makes sense to many people, and it doesn't matter really. And well, usually in most cases, those would actually be permanent bar as well, that you may never be able to overcome that, because typically, well, as I mentioned before, the good moral character is a 5 or 3 year look back. However, certain actions that you take will permanently bar you no matter how long ago they were. Some other bars would be aggravated felony. So this is more of an immigration term. Sometimes certain criminal acts may not be considered by the state or even the federal government criminal law as a felony. However, immigration law is different. They'll look at a lot of different factors to determine in the view of immigration that certain acts are an aggravated felony. Then we also have other crimes involving moral turpitude. So these would be crimes like things like even tax fraud, things that are considered as far as theft, certain other actions that the government considers really reflects on the moral character of that person. So there's a whole list of crimes like that. We don't have time to go through all of them, but those, if you have had any offense in that way, you do want to make sure that you determine whether those offenses would be considered a permanent bar or a discretionary bar. Of course, drug trafficking or habitual drug use can also be that, and another be a permanent or required bar. And then we have polygamy as well as a required bar. So again, but these are examples. These are probably examples that are not as frequent. What you will find more so are these discretionary bars, and these don't necessarily have to be crimes in itself. So this could be that the USCIS officer that is looking at your case may find that you don't have good moral character because you failed to pay child support, for example. You failed for men who had permanent residence between ages 18 and 26. If you failed to register for selective service, which is what we call the draft, military service, that is required for men in the U.S. between those ages. So if you fail to do that and you don't have a good reason why you failed to do that, then that can also be a bar against you getting citizenship. Tax violations, not filing your tax returns, not paying past due taxes, that would also be the case. So oftentimes, if that is the case, and the government now has a lot more interaction with the IRS to find out if someone has not paid their taxes. So if you have not paid your taxes or past due taxes, or you haven't filed tax returns, you have to make sure you get that taken care of before you apply for citizenship. If you have had unpaid taxes, but you have a payment plan with the Internal Revenue Service, the IRS, then that would be acceptable because you have been working on, paying those taxes back. Then if you have certain crimes that were committed during the 3 to 5 years before applying for naturalization, they could be discretionary bars as well. Now, these would be little lesser crimes that may not be permanent or required bars, but for example, shoplifting could be considered a discretionary bar if they were committed, if that shoplifting charge and conviction was within that 3 to 5 year period. Even something like a DUI could potentially be an issue as well. So these are others. If you have those kinds of things that have happened, unfortunately, in your record, then you definitely want to look at that before and get the evaluation from an attorney before applying for that. Then the other key part is really important to really look at your I mean, most people, this is not an issue, but what happens is that sometimes there may be a discrepancy in something that you provide, information you provided in an immigration application or even a naturalization application from what is actual fact, and it may be a minor situation. But if the government believes that you gave false information in any immigration application, whether it's your green card, visa, whatever, and they go back and look at that history, or even in your current naturalization application, then that could also be a bar if they determine that the information was false. So you want to be very, very accurate in all of your applications so you don't have that situation. Some of the changes that were recently announced by the Trump administration back in August, not that long ago, a few months ago in August, is regarding good moral character. So it's a little vague. Many attorneys feel like this is kind of difficult for administration. But what the government has said is that when they're looking at good moral character, they're not only going to look at whether or not you've never committed a crime or had any offense on your in your history at all. What they're going to look at is a totality of circumstances. So not only are they going to want to be sure you don't have any crimes, but they're also going to look at what they say the whole picture of your life to determine what is your good moral character. So they're not only considering whether you have avoided any wrongdoing, but what positive things you have done. So according to the government, the goal is to determine if you're truly worthy of the rights and responsibilities of U.S. citizenship. So the government has laid out a couple of evaluation standards for that, and I've put this on the slide, and you also have that in the handout that I've included, and I'll upload that again, where you can see the link to the actual memorandum. Again, it's very vague. There's not advice from my part or from most attorneys in terms of providing information that would establish good moral character, because it's very difficult to understand good moral character on the side of showing positive things that you've done. So far, we've not seen any requests for that kind of information during citizenship citizenship interviews, or even during the process in itself. So it's hard to say whether that's going to be really how they're going to address that kind of approach. But it is something to be aware of, that if you're newly applying for citizenship, you may want to think about not only the fact that you have no criminal record, which is great, but what other actions do you take? Are you involved in certain, charitable organizations? Are you a good neighbor? It's very vague in itself, but essentially we'll have to see how the government is going to really apply this kind of standard. Another part of that is what the standard that they're saying is that they're going to look at community service and involvement, again, helping in schools, nonprofits, groups. If you have community service, they're going to look at that. They're going to see, making sure that if you're caring for your children, of course, child support, which is already a part of the consideration. But even if you don't, if you are together with your spouse, to show that you are taking care of your responsibilities. They're going to look at your education background, your work history and professional accomplishments, how long you've been in the United States, your financial responsibility, making sure, of course, again, paying taxes, maybe credit history, all those things. So it's kind of difficult. It would seem to make the process a lot longer for them to have to go through all of request this kind of information. And so far, again, we have not seen any requests for that, but be mindful that we may be going down that path where we will be seeing those kinds of requests for certain information related to these kinds of considerations. Another change or potential change under the Trump administration was also announced in August about neighborhood investigation. So if you're applying for citizenship, the government has now said that not only are they going to be looking at your application and what you inform them of as far as the information in your application, and looking at your, if there's any criminal history, again, the good moral character, all that, but they may also now reinstate what's called neighborhood investigations, which ever since I've been practicing, which is 30 years, I don't think that's ever been a process. Apparently, this is something maybe 40 years ago, 50 years ago, that was a process for citizenship applications, but has pretty much not been used at all. So, but the government under the current administration says we're going to reinstate this potential for um, for the Immigration Office, the USCIS, to investigate you, the applicant for citizenship, based on conducting interviews with your neighbors, talking to your employers, just verifying the information, determining whether, what has been the good moral character that you've exhibited in your community, those kinds of things to cover the 5 years before you apply for your citizenship application. Again, this is to me a little vague, and it's kind of to me difficult to see how this can be done without delaying applications quite a bit. And again, we've not heard of this actually happening, but this was announced recently in August, so we will have to see what comes forth from that. Then finally, as far as good moral character change, there is the unlawful voting issue. Now, unlawful voting has always been an issue with citizenship applications or naturalization applications because, of course, in most cases and most elections, only citizens can vote, but sometimes people have mistakenly are not understood that they are not entitled to vote and may have voted despite, despite the rule. And sometimes we have had cases where people have done that, but we have shown that they weren't aware or they were not notified that they had to be a citizen in order to vote. And so there was still an ability to overcome that kind of bar in order to become a citizen. Now it seems that there may be very little opportunity for that to happen, where there is some discretion for the government to sort of forgive unlawful voting, according to the Trump administration, if a applicant for citizenship and naturalization has voted in violation of any state or government regulation, they will be issued a notice to appear, which basically is a document charging them with removal or deportation from the U.S. Unless that person can meet certain exceptions, which are very, very narrow. It's almost no one can meet those exceptions as well. So if you've had any instance of unlawful voting, then you may not at this time consider wanting to apply, but definitely reach out to us or an immigration attorney to really get a solid understanding of the implications for you. But this is serious in the sense that not only would your application be denied if it's determined that you voted unlawfully, your citizenship application, but you would also be placed into deportation or removal proceedings. So that's something that is very, very serious and to be considered if you're in that kind of circumstance. Hopefully not. So leading to that is who in general should not apply for naturalization. And again, this is not a blanket, do not apply. Definitely when you're looking at your situation, reach out to an attorney to really determine whether or not you should. But in most cases, if you have been convicted of aggravated felony, you've ever made any false claim to being a U.S. citizen, whether as a permanent resident or even before you became a permanent resident, if you've ever given misleading information to the government for immigration benefit, or even it could be for other government benefits as well. You need to be careful with that. If you have been convicted of a crime of moral turpitude within 5 years of admission. So what does that mean? That really means like if you have received your green card and within that 5-year period of receiving a green card, you were convicted of a crime such as fraud, for example, a crime involving fraud. So even though it may have been, you don't apply for citizenship within the 10 years, well, in that case, I mean, even if you don't apply, even if it's at more than 5 years since that happened, And you also are still qualified because you've been a green card holder for 10 years. The fact that within the 5 years that you became a green card holder, you committed that crime could be a bar to your citizenship, and it also could be a possibility of removal or revoking of your green card. So you want to be careful with that as well. And then, as I mentioned, for unlawful voting, seems to be very little leeway in terms of addressing any kind of unlawful voting issue. So next, I want to address the English language ability. And keep in mind, again, if you have questions, feel free to put them into the chat. But the English language ability, of course, has always been a requirement. It is still a requirement. Basically, the testing for English language is that you must usually are tested at the interview itself. So when you go to the interview, you are expected to speak in English. Usually, a translator is not allowed unless under certain circumstances, like a disability situation, which I'll discuss in a minute. You must be able to read and write at least one or two basic sentences. And usually what happens is that the officer asks you to read one sentence at basically about fourth grade level English. So they'll allow you to do that, and they'll ask you to write one sentence at the interview. Now, sometimes you can be exempt from the English requirement, and that depends on your age and the number of years that you have had a green card. So what we have here, what I've listed here, 50-20, if you're 50 years old or older and have had your green card for 20 years, then you can be exempt from the English requirement. If you're 55 years or older and have had your green card for 15 years or more, then you can be exempt from the English requirement. But that's pretty much the only exemption as far as age is concerned. Now, as far as there is a what we call an N648 disability waiver, which we'll talk about more in detail in a minute, but that's where there is that will be a total exemption based on the fact that you're unable, because of a disability, to learn English in itself. So also important is the U.S. history and government testing. So there is an exemption from that if you are 65 years of age or older and have had your green card for 20 years or more. You can take a simplified test of the government and history civics test, which means that you can take that test in your native language. So right now, and what that means so is that you would have to answer 10 out of the 10 questions out of a bank of 20 questions. So there's a limited number of questions that the government can ask. So they can only ask 10 questions out of a list of 20 questions. And then you would have to get at least 6 of those questions correct. Now, this is the same. This has not changed in the Trump administration, but there will be some change overall that I'll discuss in the next slide. But in addition to the exemption from the U.S. History and another exemption from the U.S. history and civics test is the N648 disability waiver. So if you're established that because of a disability, you're unable to answer these questions or take the testing, then you are exempt from that as well. So what is the history and government history and civics testing, or I say government testing? So currently, if you have applied already before October 20th, so before Monday of this year, Monday or Tuesday, I think, no, Tuesday. Sorry, Monday of this year, then you are going to go with when you have your interview, you will still continue with the old tests of the 2008 Naturalization Civics Test, which that is answering 10 questions out of a bank of 100 questions, or a list of 100 questions. So if you study those 100 questions and you are able to answer 60% of those questions, or at the interview, you would be answering 10 out of the 100 questions. And if you're able to answer 6 correctly, then you would pass the test. However, those who filed their application as of Monday, October 20th, and going forward, then you will now be answering the 2025 Naturalization Civics Test, which now has a bank or a list of 128 questions, and you'll be asked to answer 20 questions out of those 128 questions. And out of the 20 questions that you're asked, you would need to correctly answer 12 questions. So it's a little bit higher, yeah, a little bit higher, almost about the same 60% rate actually, for that. But essentially that's what you'll have to study. So all the information regarding the testing is on the website, as I have on the link here, the USCIS website. So if you follow those questions, study those, then you should be able to pass the civics test as well. Now, let's finally talk about the disability waiver. So this disability waiver applies, it's not age specific, it's more based on your mental and physical ability. So what it does is it exempts a citizenship applicant from English and the history on the civics testing. But in order to be exempt from that, you must have a physician, qualified physicians or psychiatrist or primary care physician or some qualified physician or even other psychologists, someone who is qualified to give a determination that you are medically unable you are unable physically, developmentally, or have a mental disability that is going to be long-term, meaning that it's lasted more than 12 months or more. And because of that disability, you are not able to learn English or U.S. history and civics. So it's very important that the physician or the medical professional that completes this N648 disability waiver be very detailed and explain what the disability is and why it does not allow the individual to actually learn English or take the test. Sometimes we've seen physicians do this and not really give enough detail, and the government has kind of thrown that form out. So it's really important that if you want to try for the N648 disability waiver, make sure that physician is very detailed, does a good history, especially if they're not actually treating that person for the treating you for the disability or treating the person that you're helping with the disability. They need to make sure they do a thorough examination and medically explain why they're making that diagnosis or signing off on that form there. Okay, so next we'll talk about the actual process of becoming a citizen or naturalization. So far, the process has really not changed this year in terms of how to apply. The forms have changed somewhat, and they probably expect some changes in the future as well, especially considering the August 2025 directives that have come out about good moral character. So, but it currently, the form is online, or you can complete it by paper. Do recommend, especially if you're doing it yourself, to go online and do it and try to be sure that you're inputting the information correctly. But going online really does, we've noticed, speed up the process because, of course, once you submit the application, you immediately get your case number. You immediately start to get notices about well, not immediately, but you soon after get your notices about the case. You can track your case a lot easier, although you can still track it if you mail the application, because the government will give you a online case portal or account that you can use to track your case. But filing online usually has been a process that has seemed to also cause the cases to be processed faster and potentially have your interview faster. But usually what happens once, whether you file by paper or mail or online, the next step would be that you would get your receipt notice, which you use to track your case. And then you will expect to get a biometrics appointment notice or a notice saying that we are not going to require biometrics, which is your fingerprint, taken at a local office. Instead, we're going to use fingerprints that we might have had from your green card application or some past application. So, but you're going to get a notice either way that you need to go to get your biometrics done, or that you do not need to get your biometrics done. Then after that, what you can expect is an interview notice. And right now, time frame, it really depends on the location where you are in the country, but in most cases, we have been seeing about 6 months or so for most cases. Again, there's no guaranteed processing time to any of this. The government basically says when we get to it, we get to it. But essentially, we do see sort of an average time of 6 months. But even if it's taking more than 6 months, or it doesn't necessarily mean there's an issue with the case. It's just basically pushing the paperwork through and getting it through the chain. But the next step after the biometrics, and then eventually you would be hearing from the government saying you're supposed to attend the interview. And the interview is where you will do the English testing. You will also do the government testing. And in addition, of course, they will review your application and ask you questions to confirm the information that you provided in your application, have you sign off on the application again. And then after all of that is done, you usually will you will usually be told at the interview either that you've passed and you will be moved to the next step of oath ceremony, or if there is an issue, there may be a request for more information. Or in some cases, the officer says, I can't make a decision yet. I'm going to have to, run this by my supervisor. Doesn't mean there's anything wrong with your case. It's just an internal process. But those are things that could happen. But best case scenario, of course, and that's what we want to look for, is that once your interview is over, then you can expect to have your oath ceremony. So your oath ceremony is where you actually do become a citizen and receive your naturalization certificate. It is generally a group ceremony with many people who have applied for citizenship. It is a ceremony that oftentimes you are allowed to bring guests to the ceremony to congratulate you and to welcome you into as a U.S. citizen. So it's a very happy time. It doesn't usually last very long, probably about about an hour at the most, depending on the number of applicants that are there or the candidates that are there. But that's what you can expect. Typically after the interview, you usually see about a month or two to receive your notice to come for the oath ceremony. After the oath ceremony is done, you will have your naturalization certificate, and the officers there will give you some direction as to how you use that certificate or how you want to protect that certificate. But it's also very important, we definitely recommend that you apply for your U.S. passport, because once you become a U.S. citizen, your green card is no longer effective for travel. You will need to have a U.S. passport. And that is a different agency that you have to apply to. You don't automatically get it through the citizenship process. You have to apply to the Department of State for your passport, and timeframes can vary. But if you do not want to have any issues about travel plans, you want to apply as soon as you get that naturalization certificate. There's also you're now able as a U.S. citizen to register to vote. So you want to, sometimes there are officials there at the ceremony to provide you information to register to vote. So I would definitely suggest you do that. Of course, there's no requirement to register to vote, but it would be a great idea to do that and be able to exercise your full rights as a U.S. citizen. Now, as a U.S. citizen, you're also eligible for jury duty. You'll be eligible for many positions that are maybe government-related positions that require security clearances. There's a lot of benefits to that as well. And of course, as a U.S. citizen, you would be able to also sponsor family members such as siblings and parents, which you would not be able to do as a permanent resident as well. So I also wanted to talk about automatic citizenship. So when we talk about that, some of you may have children who have green cards along with you. They're under the age of 18. We always recommend that once you are eligible to apply for citizenship, especially if you have children under the age of 18, it's a great idea for you to go ahead and apply, because once you become a citizen, or at least one parent becomes a citizen, then the child automatically becomes a citizen. In fact, they can come with you to the citizenship ceremony and celebrate that they're also, or the oath ceremony, and they can celebrate that they're also a citizen at the same time that you become a citizen. But in order for that to happen, the child has to be in your custody as a citizen parent, physical and legal custody. And of course, the child has to have a green card as well. But how to prove their citizenship, they don't get automatically a document to prove their citizenship. What you would need to do is to either apply for their passport, which is the fastest and easiest way, and probably the least expensive way. Or you can apply for a certificate of citizenship from the USCIS, which can be fairly expensive. It doesn't alleviate you of getting a passport. So it'll be an extra proof of citizenship, but it's not required. So if you get a passport, that would be sufficient for any purpose to prove that the child is a citizen. Then we have what's called birthright citizenship. So we've heard a lot about this over the years, and especially this year under the current administration, where there's been a executive order or action or claim that that children born in the U.S. are not necessarily citizens unless their parents somehow qualify. But under current law, current constitutional law, and the way that everything is happening right now in terms of administration, nothing has really changed with that. The court case, there has been lawsuits against the Trump administration for this executive order, and right now it's still in the court system. There's not, as far as I know, any implementation of this particular order. But so right now, anyone who is born in the United States, with the exception of those who might be children of diplomats, but in general, if you are a citizen, you are a citizen if you're born in the United States, even if your parents are not citizens. And if you are a U.S. citizen and you have a child outside the U.S., then they may also be citizens at birth. They can receive a birth certificate from the Department of State or the U.S. Embassy, but it depends on how long you lived in the United States. So you have to determine a lot of there's a lot of questions to answer before you can determine whether the child can actually derive citizenship or be an automatic citizen upon birth if they're born outside the U.S. as well. And then lastly, I wanted to talk quickly about denaturalization. This is something we've also, as I mentioned earlier, we heard quite a bit about in the current administration, where there seems to be a push to look at denaturalizing people, or at least under the first Trump administration. It was about a 300 or 400% increase in denaturalization lawsuits against people who had obtained citizenship. So just to understand what that means, it sounds scary, and it won't apply to everyone. It probably won't apply to majority of barely anyone would be denaturalized, although there would be, there is concern that it is done appropriately so that someone who should not be denaturalized does not have to undergo this. But denaturalization is when the government takes away citizenship that you receive through naturalization. So it cannot happen by the USCIS just saying, hey, you're no longer a citizen. You actually have to have a court order. So it has to go through pretty much a lawsuit, but the government has to file against you to say that you're no longer entitled to be a citizen. So they have to provide strong evidence that you either got your citizenship illegally or by fraud, something, was fraudulent in your application, or in some cases, there may be a criminal conviction for naturalization fraud, but once your citizenship is revoked, then you return to your previous immigration status, which could be a green card, of course. However, in some cases, they could also look at revoking that depending on what the circumstances are or why they believe that you should no longer even be a permanent resident. So it can be a little scary process, but the main reasons that the government would have for denaturalization is, again, misrepresenting or concealing facts on your citizenship application or during the interview. And this could be, for example, you had a criminal history and somehow they did not find it, but it turns out it was a criminal history there. Or even if it wasn't a criminal history, but maybe later you are determined to have after you became a citizen, you've determined to have committed some kind of crime. And if the facts underlying that criminal charge happened while you were applying for citizenship or before you became a citizen, that can also be considered a basis for denaturalization, because they would say that you were doing these certain things. And there's cases out there where people have been convicted of certain crimes, and during their citizenship application, they're saying, okay, well, you knew you were doing these unlawful things while you were applying for citizenship. And one of the questions on there is not so much, one questions is, have you ever done anything that would be considered a crime? And of course, you said no to that. So that was misrepresentation or concealment of facts. Another basis for denaturalization is if you were never eligible for citizenship because maybe the government made a mistake. They say illegal procurement. It either could be that, in that case, it would be more like the government made a mistake in terms of determining whether it's good moral character, continuous residence. Somehow they should not have approved you for citizenship. And then in addition, the last one, which is pretty rare, is you were involved with a terrorist, totalitarian, or communist organization within a certain time frame there. So with that being said, we do have some time for questions. I do see we have some questions there. I do want to advise everyone to make sure your questions are general in nature. Try not to disclose any personal confidential information. This is a public forum, and we want to be sure that your information and your process is secure as well. So let me see if I can find out any of the questions that we have here. Okay. So I have a question here. How does good moral character apply to elderly dependents who have only obtained green card based on their U.S. citizen children? So, well, good moral character applies to anyone. It doesn't matter how you obtained your green card. What matters is the 3 to 5, well, the 5, in this case of elderly dependent parents, that would have been within the 5 years, within the period 5 years after they received their green card. Have they, had a clean record, no criminal charges, that kind of thing. In the current administration, in terms of showing overall totality of circumstances, it's hard to say what would be required, but if you have community, there could be some other information that could be provided for that. I really don't think they're going to go that far as those who are elderly, in terms of trying to prove their worth as applicants, but it really doesn't matter how you obtain the green card. Good moral character is going to apply to anyone. After naturalization, another question is, after naturalization certificate, is green card invalid? Should emergency travel arise? What to do? Yes, your green card is invalid. Sometimes they do ask you to bring your green card and to give them your green card once you have gotten your naturalization certificate. So you need to immediately, as I mentioned, that's why if you have, you never know about emergency travel. So as soon as you get your certificate, you need to go ahead and apply for your passport. Passport timeframe can be about 6 weeks. There is expedited processes by paying the Department of State additional money to do that. Sometimes it can be done in 1 or 2 days, but you really need to make sure that you go through that process. So you can't, if you just leave with no passport. All U.S. citizens are required to show their passport when they return, no matter whether they're naturalized or not. So you need to be sure that you apply as soon as possible. Another question is, are there any questions in the interview to confirm good moral character? If so, any examples? Well, the questions were the same questions that you will find on your citizenship application. They ask you, have you ever committed a crime? Have you ever received citations? Have you ever done anything that would be considered, an indication of not having good moral character, or a crime, that kind of thing. So if you look on the N400 application, you will see all the questions, at least currently, that they're asking about as far as good moral character. Those are the questions that usually they will also ask, not only on the written application, but at the interview as well. Another question is, what is the current estimate time for green card holder filing for spouse in the U.S.? Is the process getting faster? So this isn't a citizenship question, but certainly I can answer that. Basically, depends on where you are. You can find kind of the information, we'll find information on the USCIS website, dependent on your state. district office. In most cases, we're just seeing just rule of thumb. We are kind of seeing about 6 months for those applications. Some of them faster than that. I don't see it getting processed faster than the previous administration. I think a lot of what happened under the previous administration is continuing on until they start making more changes under this administration. But as far as timeline is concerned, it seems pretty consistent from last year as well. Are there any other questions before we conclude? Have time for one or two more. While we're waiting, I'll just wait another minute. Just wanted to let you know again that you want to be sure that you use this information in a way that you would to intelligently ask questions to your immigration attorney to be sure that you are totally covered under these circumstances for your citizenship application. I'm going to go ahead and put up our information to contact us directly. I do see a few other questions. Are there any delays due to the current U.S. government shutdown? It's a good question. As far as citizenship applications and most applications are concerned, there's not much of a delay. There's not any delay actually because the USCIS is not federally funded or funded by the government. It's funded by the fees that you pay. So they're still operating. Nothing has changed with operations as far as the USCIS is concerned. If there is an application that is an immigration application that is dependent on other agencies, so for example, H-1B petitions are dependent on the Department of Labor, then there is a delay because the Department of Labor is shut down. So we're not able to apply for LCA. Labor condition application. Also for the PERM green card process, which is administered under the Department of Labor, there is a shutdown on that end. And so we're not able to process those as well. I did upload, the next question is upload about the slides. So I did upload the slides. We will have the recording of this session on our YouTube channel. So we'll be sending you an email about that. A next question is, if I have a major accident recently, does it affect the car accident? I'm sorry. Where it was caused by you, does it affect naturalization process? It depends on it depends on whether there's any charge related to the accident, meaning a criminal charge. If there's no criminal charge related to the accident, it's highly unlikely that's going to cause, it's an accident, so it should not affect your naturalization process. How soon can we start and submit the N-400? Well, it depends on your background, immigration background. So certainly if you're qualified in every way, having the required time and, good moral character and all those things are in place, then you can start within 90 days of your 5-year anniversary or your 3-year anniversary of your green card. Again, that depends on your circumstances. If you have already passed 5 years, then of course you can apply at any time for your N-400 application. Okay, I think that is all we have for today. I want to thank you all for attending. Please keep us in mind for future webinars. And if you need any assistance, please feel free to reach out to us at any of these contact platforms that you can. Thank you so much and have a wonderful day.